Thanks a lot for coming today to this morning digital event by Disrupt. The topic is tokenization of everything now possible in Liechtenstein. And we have an exciting panel today of experts around this topic. I'm excited to see what comes out of this discussion. Philipp is our moderator, and we will have a quick introduction by each of the panelists, Christian, Thomas, Sofia, and Simon, right after my quick intro and a quick presentation from Sofia. Before we get started, as always, there's going to be interactive components as well. So Philipp and I will monitor this WhatsApp group for any questions that you have. So if at any point you feel like you want to ask a question to any of the speakers or into the panel as a whole, then you can just post it in this WhatsApp group. And if we have enough time, we'll pick it up and ask this live. So then you can have your answer. If there is not enough time to answer your question, be aware that all the speakers are in there as well. So we hope to, and we encourage you to carry on the conversation after the event is over.
Yeah, I would propose that we quickly ask Sofia. I think she's sponsoring this event, right? So let's quickly present what Sofia and Amazing Blocks is doing.
Yes, of course. So welcome today, and thank you, Jan, for the nice introduction. I want to start by telling what's Amazing Blocks and what we are doing. So I'm just sharing our pitch deck presentation. So I'm responsible for the Amazing Blocks. I'm the CEO, and we are newly founded Liechtenstein stock corporation. So we're founded like a few months ago. And the reason why we're here together all is that at the beginning of the year in Liechtenstein, the legislators decided to publish a new law called the Liechtenstein Blockchain Act. And this is completely revolutionizing the blockchain environment because you're now able to put almost every asset in the economy in the so-called container model and like tokenizing and share it with our shareholders. This is not just possible in Liechtenstein and the rest of Europe, as you might know in Germany. It's just like a vision that is not created at the moment. So what are we doing at Amazing Blocks? We want to establish newly founded companies by bringing their equity tokens on the blockchain. Why we want to do this? Because we think that this would create full automation. It's everything remotely. You have this bankless incorporation, and you have this fundraise on the go. So all in all, this means that building a digital stock operation and bring it on the blockchain has tremendous benefits that was not able in the past. Why? As we by our own did this traditional method of establishing a stock corporation, we saw that it's just not only take a lot of time, like 3 to 4 months, but only it's costly, it's time consuming, and it's just paper-based. And we want to revolutionize all these steps by making it digitally and bringing them on the blockchain. But we have also other benefits. As you may know, we have this digital shares register, the Aktien register, that has all your shares digitally actualized. We have this digital asset investing and ownership transfer, so you can easily transfer your shares and tokens with new shareholders. And but also digital fundraising and engagement and ESA programs are now completely new way because it was not able before to bring them on the blockchain and have them digitally. So all in all, what we want to do is to find blockchain startups that want to make their startup on the blockchain and have this new Liechtenstein blockchain stock corporation. But it's not this. You can imagine like this stock corporation, this Liechtenstein corporation is like a legal wrapper. And then you can put every asset in this legal wrapper and tokenize it. So if you have any machines or you have cars in your company that you want to tokenize, you can do it completely easy. So, and that's the reason why we're here together. And we want to revolutionize this by using our new token pad. So we have a software. We want to sell a software as a license where customers are able to tokenize their shares individually. So, and if you have any other questions, also at the end of this panel discussion, you can just contact me, telling me what specific questions you have. So, thank you.
Excellent, thank you. That's fine. So now you have presented yourself. So therefore, let's quickly move on, and maybe everybody in the round quickly presents himself. Christian, would you like to start quickly present yourself?
Yeah, sure. Good morning. So I'm Christian. I'm working for Blocksize Capital. And at Blocksize Capital, we're pretty much focused on secondary market infrastructure. That means now with all digital assets coming up and new tokens being issued, I think the market is lacking something, infrastructure for trading those security tokens and bridging exchanges and investors. Also, the entire cycle of clearing, settling securities nowadays works through a centralized security depository such as Clearstream. In the future, those securities and those tokens, they are cleared and transferred completely different. And this is exactly the infrastructure that we provide mainly for banks, financial institution, broker dealers.
Okay, excellent. So this is including digital assets, right? Plus crypto assets, both. But as there are no digital assets at this point of time, or not too many, then that's why it's primarily crypto assets. Okay, Simon, would you like to present yourself quickly?
Yeah, my name is Simon Peters. I'm working for Decus Network. We're working on a middle layer solution to bridges the gap in custody. So we're all about custody and making it much easier and much more integrated in our systems. And so we are all about infrastructure. And I'm very happy to see what Sofia is doing, because of course we can build all these infrastructure, but we need to utilize legislation to create these values and these assets. So I'm very excited about that.
Okay, excellent. And finally, one of the key law firms from Liechtenstein, without Thomas Nägele in specific, and also a couple of other people, there would not be a Liechtenstein Blockchain Act or Liechtenstein Token Act. Maybe, Thomas, would you like to present yourself also?
Sure, Philipp, thank you. Good morning to everybody. My name is Thomas Feldkircher. I'm partner at Nägele Attorneys at Law. As Philipp has already pointed out, our law firm deals mostly with blockchain-related businesses by advising them, doing their fundraising, but of course also intermediaries implementing the technology into their existing core business. My personal background is I'm a Liechtenstein attorney admitted to the Austrian bar as well, and I'm a securities lawyer. So coming from the old days back then, securities law, supervisory law, and with a special focus on civil securities law. So that is a perfect match for today, I think, since we're talking about the question if tokenization is basically possible for everything.
Excellent, thank you very much. So Thomas, first question to you. I'm actually personally very much interested in this, in the answer. So what is happening in Liechtenstein so far? The law has been put into force in January, as far as I know. So that's now 8-9 months, right? So what has happened in these months, and what would you expect in the next 1 or 2 years to happen?
Yeah, correct. The Token Act got into force with the 1st of January this year. Yeah. We were glad that our parliament passed that governmental bill, and our regent passed it as well. What happened? Yeah, as you might be aware, the Token Act is split into 2 different parts. One is a civil law part, one is a supervisory law part. The civil law part has in its core the function to bridge the gap between the analog layer and the digital. Yeah? In order to make sure, in easy words, that if you transfer the token, you transfer the right, if the token contains or represents any right. The supervisory part has the aim to supervise or to regulate, slightly regulate, TT, trusted technology service providers, in order to justify that trust people have by using that system, by supervising them from the Financial Market Authority. Now, what happened? Of course, we have some development from participants that are already established or were established before the Blockchain Act came into force, which are now or have already filed their application for registration. Yeah, the first registered TT service provider is, since it is public, you can convince yourself, is Bank Frick, yeah? Which was the first bank which was interested in the whole blockchain technology in Liechtenstein. The FMA has, I had an informal chat with them, has yeah, quite a lot of applications on the table, quite a lot of new players informing themselves about the regulation which was brought into force with the Blockchain Act. We as a law firm have a lot of work to do. Glad to say that, of course, as an entrepreneur as well. And therefore, I think that the big aim of the governmental bill to attract serious entrepreneurs and to give them a legal basis to act, yeah, is fruitful, yeah, because it is accepted, yeah.
Okay, and one more question to you, Thomas. What are companies now trying to do in Liechtenstein? Are they tokenizing art pieces, cars, machines? So how creative are they? What are you personally surprised? What you get on your desk in terms of inquiries? Or is it like standard securities now being tokenized, like a stock or a bond?
No, that is, of course, that is very, very astonishing. Of course, I can't go too deep, yeah, since or due to the attorney-client privilege, but everything I tell you is public knowledge. Yeah, you can find it in the internet yourself. Therefore, yeah, as you pointed out, there are, of course, the ones that are dealing with the tokenization of securities, yeah, but that is, of course, something which is highly interesting due to the amendment of our Persons and Companies Act and the automatic transfer or the automatic transfer of the creditors' rights or the membership's rights from person A to person B if the token is transferred. Yeah, that is a very interesting mechanism from a corporate or civil law points of view. And that is, of course, one big group, but the other seizes the chance really to tokenize rights in respect of physical goods, which are under certain circumstances, at least, not deemed to be a security in the supervisory sense.
Okay, interesting. So, Sofia, what's your take on this? Apparently, you are a very young company, but probably also talking to first companies. What do you see so far of companies being interested in the Liechtenstein Token Act?
So, in my opinion, as I told you, so we are like issuing equity tokens. I think from stock operation, I think this is one really interesting industry where you can like build your own company by doing this. But I also see a high demand in like tokenizing different various assets. So for example, I had one company that wants to, for example, tokenize the rights of musicians or the rights of famous people from the sports sectors. So I think the tokenization is opening a completely new way of get into liquidity. And so in my opinion, there are a lot of industries that will focus on that.
Okay, interesting. And Christian, you also see a lot happening in your email inbox, probably day by day, new inquiries. Would you agree on all this, or is it basically stuck to the traditional legacy financial instruments, which are mostly interested? Is it new financial instruments being tried to be tokenized, or is it, let's call it, legacy instruments?
I'd say both. We see clearly a high demand for illiquid assets to be tokenized, and by doing that, create liquidity, which is IP rights. But also we receive some very interesting inquiries where people want to tokenize racehorses, a Picasso painting, and provide fractionalized ownership for that. Then also already some football players, they issued their own token. James Rodriguez, for example, in Singapore, former Bayern player. We speak into football clubs that look into that. Tennis is also, sports in general, quite interesting. So yes, we clearly see that. It's getting more and more exotic, I think, by the day. You can say that. People have great ideas of tokenizing things. But I also, want to say it's still very early stage. Now we just see the first initiatives of amending existing legislation in order to allow issuing those securities. But you always have to keep in mind, once that security is issued on the primary market, you could theoretically transfer it, but something that the market is completely lacking is liquidity, right? And that would be the ultimate kicker. So the first stage was cryptocurrencies, and this is something that works already pretty well. Although still, you could consider it as a niche. But for security tokens, it feels like we're just getting started. And I'm really curious to see whether the development will be similar to cryptocurrencies. That means that now secondary market exchanges will emerge, that there's a need for infrastructure to clear and settle those securities. So yes, I think it's just starting, but I also think there's a lot of work to do, especially from the regulatory side.
Okay, one more question, Christian. Why is there no liquidity? That basically induces that there are hardly any investors at this point of time. So why is it? Is it regulatory concerns? Is it knowledge on behalf of investors? Is it the custody business, which is just developing these days? Or do we have to wait, sorry to say this, do we have to wait for the inflation coming from the governments around the world to then basically push money into real assets, which would also be possible?
Yeah, I think the first thing that we have to keep in mind is that the German government, for example, just acknowledges profit participation rights, right, as a security and provided a clear legal framework. We're still a couple of months, if not years, behind Liechtenstein, where it's possible under civil law to tokenize specific claims. And this is something that will happen soon. However, it's good to see that at least the regulator acknowledges that stocks and mutual fund shares could follow. But I think one thing is that is required to do is a clear legal framework that allows institutional investors to invest in that. And then the second thing is we need applications. You can't actually convince a family office to set up a MetaMask wallet, store the seed phrase somewhere and handle the private key and then invest a couple of millions into that. This interface clearly does not work for institutional investors. And I think the market...
Why not? Just a joke.
Yeah. No, but it's true. They need education. We usually lose them in those discussions when we just introduce the concept of public and private keys. And if we then tell them, look, if you lose your private key, that's it. You can't access your asset anymore. That's it, right? This is where you lose them. And a lot of them are not that tech savvy. They're interested in investing in new asset classes, which do not correlate necessarily with traditional stocks, but just the lack of infrastructure is preventing them to do so. But we're seeing a lot of things happen with companies such as Decus, but also Amazing Blocks to provide that infrastructure and make it easier to invest in it. But yeah, I think it's a mix of all. We need the proper infrastructure to do so, right legal framework, but we also need very, very important elements such as secondary markets. Something that we still have to figure out, how does that work with with CSDR and securities theoretically being issued through CSDs in order to be traded on an MTF or OTF. But slowly it's emerging.
Okay, thank you, Simon. You're also talking to people potentially wanting to store crypto assets and so on, right? So, what is your experience on this question? Why is liquidity lacking? Why are investors maybe interested but not acting yet?
Yeah, a little bit what Christian said. The market is still very, very much immature. It's start kicking off. And I think we will see, or from my experience talking to clients, we'll basically see a movement in these areas where the pain point is the biggest. So what we've heard before, like we can tokenize things like art or real estate. From my experience, the first markets that will move and that will become liquid will be the markets where the pain point is the biggest. And this is much rather something like real estate than art, because the pain point for having huge assets that are in liquid in maybe in times where we, as you said, maybe see high inflations and maybe see some instability in the market, given everything else that's happening, it's much more attractive than just having that idea of owning, okay, 1,000 of a Picasso. And so my opinion is, and also what I get from clients, that we'll see these movements in specific markets like real estate much earlier than in other parts. Of course, there's also interest, but I think especially real estate will be the one that kicks it off, and then together with other classical securities. But real estate is just that super attractive case because there is such a big pain point that dissolves by tokenizing an illiquid asset like a house. So this is where I see the big movements within in the foreseeable future. So we talk maybe 18 months, then we will see. In 18 months we'll be in a much different place than we are right now.
Well, in 18 months, that's my personal opinion now, we will enter a high inflation phase of 10 years with what we can now expect to be. It will be fascinating next year to maybe either see interest rate may potentially drop below zero, who knows? Mm-hmm. Alternatively, strangely, it could be an inflation rate occurring between 5 to 10%. If you have this for a couple of years, then half of the purchasing power is just diminishing. And this will really drive people, in my personal opinion, to invest in real assets to basically keep their value. That's, I think this is what's happening, but let's see. Would you agree with this, or is it basically too speculative at this point of time to basically apply this logic? Yeah, that's.
I believe it will happen earlier. I believe that we already this year will see some major moves from financial service providers, banks, moving into that. We're working together with a few financial institutions to provide exactly that infrastructure and provide that infrastructure to institutional investors. And I think there will be a few very exciting transactions happening this year in Liechtenstein, Switzerland, and Germany, which will basically set the ground and attract more institutional money to flow into the market. Curious to see still what the market looks like in 18 months. Will it completely take off or will it slowly emerge? But I'm pretty sure, and I know that this year already something will happen.
Okay, so that we have 4 more months to go, which should be exciting. I would agree here. Sofia, you told me previously that apparently, for example, one company approached who wants to tokenize old-timers, like classic traditional cars, right? So what is, I don't know if you can talk about it, but what is their ambition? What do they want to have, and why are they doing this?
I think especially when you compare old-timers, so as you might know, old-timers are expensive. And I think it's a great possibility to tokenize old-timers, because imagine you want to have a share on these old-timers and have the right to, for example, use these old-timers like 10 times in a year. I have the opportunity to have these old-timers do like, or take part in some races. Then you have the ability to use like a small liquidity to invest in this old-timers, and then you are able to, yes, have the benefits of it. And before that, it was really difficult because you had to pay the full amount of these old-timers. And these companies who want to invest in these old-timer industries see a great advantage in using this tokenized model, because you have a wide range of people who want to invest in that. And they see great potential in, yes, leveraging these acts.
Okay, and maybe Thomas, on the car question, I think there is a company from Switzerland who has already tokenized cars. I think it's not traditional classic cars, but it's rather like very speedy racing cars, right? So this already has happened in Liechtenstein, right? And these guys already applied the Liechtenstein Token Act. Is this right?
I think that was, I would have to have a look at the prospectus register. If the Token Act was in force back then, I don't think so. But of course, if the issuance endures further on, yeah, of course, then the Token Act is applicable. As far as I am aware, as I have already mentioned, it is in the prospectus register. Yeah, so it is a classical security, a derivative, in that case, a structured product. So it's not fractional ownership in that racing car. it is a derivative, some kind of derivative. I don't know the mechanics by heart exactly, but that is of course something which was done before, back then in the old days, and which is now done by tokenizing that derivative, that structured product.
Okay, we have, Thomas, we have one question coming from the chat here on WhatsApp, asking that what about the German word is Namensaktie and Inhaberaktie, bearer assets, and I think it's called registered shares, right? So could you quickly explain what is demanded here? Is the law requiring a specific form of shares, or does it not matter? And how does this basically reconcile with the Liechtenstein Token Act? Is everything allowed? Do you need to apply specific rules here, or how is this working?
Generally, in Liechtenstein, we have no crucial distinction between registered shares and bearer shares since 2008, yeah, because in 2008 Liechtenstein decided to get rid of bearer instruments in that classical sense, that the one that has the certificate is the one that has the claim or the membership right. Yeah, so our bearer shares in Liechtenstein are since 2008-9 registered. Yeah, so there is not much of a difference. The crucial difference got into force or place with the amendments of the Persons and Companies Act, which contains our civil securities law, and which came along with the enforcement of the Token Act, yeah, because now it is stipulated there that there is the so-called Wertrechte in German, so digital securities are completely the same as classical securities on a paper sheet, yeah, if you want to call it that way. And the mechanics of that Wertrecht, of that digital security, is that they are registered in a register. So the constitution of that security is done by entering it into the register, and the transfer, the constitutional moment for the transfer is again the enter of the transfer into the register. And the law, Persons and Companies Act, in its securities provisions, stipulates that one is allowed to keep that register with a blockchain, with a trusted technology. And that is, of course, the charming thing, because if now we bridge the gap to the Token Act, we have that fascinating legal system. It is quite astonishing, I think, that if there is a Wertrecht, yeah, a digital security represented in a token, let's call it the digital share, which and the share register, as Sofia in her introduction told us, is kept more or less on the blockchain. If I transfer that share to you by transferring the token, Philipp, the register is updated more or less automatically, and that is the constitutional moment for getting you a shareholder.
Yeah, that makes extremely much sense. I just wonder, because in the past, some people called it the Liechtenstein Blockchain Act, right? Now people are more and more calling it the Liechtenstein Token Act. What is happening in terms of naming this law? You know, is it just people naming this law the best way how it fits, or is there some regulation, some government behind wanting to basically control how this law is being named? What's happening there?
I had the pleasure to contribute at some points to the working group, and I remember that there have been discussions on the title. Yeah, in the end, the German title of that law is Token- und Verteidienstleistergesetz in German, so Token and TT Service Providers Act, or in a short, Token Act. But before the government passed the bill to the parliament, we had that public consultation. Yeah, that is a constitutional prerequisite in Liechtenstein before a bill passes to the parliament, where everybody can contribute and tell his opinion on that. And then back then it was informally called Blockchain Act. Why did the Liechtenstein government in the end avoid that term? Because it's based on trusted technology. Blockchain is and can be a trusted technology, but since the Token Act is technically neutral, it wouldn't fit.
Yeah, that makes extremely much sense. Yeah, fascinating to hear this. Actually, I had the chance to read the draft bill of the European Union regulation, of the EU regulation, which is now coming to us in the next couple of weeks. And that was 170 pages of paper, very, very toughly to read. And actually, I was a little bit surprised that they are now taking crypto assets and putting it as a new asset class besides existing asset classes. So actually, I really wonder that they did not took the spirit of the Liechtenstein Blockchain Act to have basically the token, the technical item carrying some kind of legal right inside, basically separating the law area from the technical area. This is what the Liechtenstein Blockchain Act does very, very, very nicely from a conceptual perspective. And this makes it quite easy. And that's why your law is actually not too complicated to understand and probably not too complicated to implement, right? But I was very surprised reading the EU draft bill on the crypto regulation, and these 170 pages are not the entire regulation. There will be even more tons of pages coming where they are now not basically creating this logic separating the token as a technical mechanism from the law, but rather basically creating a new asset class for crypto assets. And inside this huge area of crypto assets, they basically plug inside stable coins, traditional cryptocurrencies such as Bitcoin, then fiat referenced crypto assets that would be basically something like Libra and also other things, you know, all in one box. And this is, in my mind, that was extremely the wrong approach, because Liechtenstein really did an amazing job with creating this separation between law and the technical domain of the tokens to basically clarify what is a token and what to plug into the token, which could be a right. Now, in my mind, this is one of the brilliant core ideas of the Liechtenstein Token Act, Liechtenstein Blockchain Act, and I was really surprised that this wasn't basically taken over in other regulations. Thomas, would you agree here? Where do you see that the Liechtenstein Token Act and its spirit has been basically embedded in other laws?
I did not have the chance, to be honest, to read through that draft bill. I got it yesterday, yeah, and that will be my lecture of the weekend. But I think, yes, that is basically the spirit the Liechtenstein Token Act has, that, and I'm surprised to hear that what you reported now, Philipp, because BaFin also stated at some point it is always substance over form, and that is the spirit, lastly, of the Token Act. Yeah, the token is information on a TT system. It can be blank information. It can contain rights, certain rights. Yeah, it must not mandatorily contain rights. But the token is information on a TT system and therefore a technical representation. Yeah. The challenge is, of course, to gap the bridge between the real world layer and the TT, the trusted technology layer. But of course, the token itself changes its qualification according to the underlying, in my opinion. And that's the only serious approach one can have here. And that is the mutual understanding in Liechtenstein, which was built since 2015, 16, along those lines, together with the regulator. Yeah, that one has to see what is the underlying, because the token is the digital representation, the container, as Sofia already stipulated or mentioned, and does not change anything. Otherwise, one could argue, if I tokenize a derivative, and if I say a token is a commodity or a separate asset class, the derivative changes into that new asset class. And I think that is not the meaningful conclusion. But yeah.
That's exactly it. You know, what I'm now saying is not perfectly true, but imagine you would basically tokenize a stock. Then in my mind and in yours, Thomas, as well, then a tokenized stock is still a stock, right?
Yes.
Exactly. And therefore, it just doesn't make sense basically to tokenize a stock. And if you have tokenized it, then it's not a stock anymore. That doesn't make sense. And some regulations out there are basically not having this thought instilled in their regulation. Okay, let's talk about costs a little bit. There was also a question here in the WhatsApp group. Christian, can you tell us something about the costs of basically tokenizing an asset? You mentioned an art piece, right? So take another example also. So what would you expect for a company issuing such assets? What would you expect to be the costs for setting up the entire contracts and the entire regulation, and what other costs would apply?
Mm-hmm. Yeah, I come to that in a second. I also have a nagging question I wanna raise. But coming back to the approach of the European Union, and I quickly summarize that in my words. We're a software company, okay? But in Europe, we've got the CSDR, which is the regulation for central security depositories. That is currently preventing us from easily listing security tokens, okay, on a secondary market. And it's slightly different in Liechtenstein though, right? And Philipp, if the European Union, and we were lucky enough to discuss that with the European Security Commission a while ago, if the European Union now takes an approach that allows to classify security tokens as a different asset class, and if this helps to somehow create an exemption of the CSDR, which will lead to security tokens not be booked into a CSD system in order to be traded, I'm totally fine with that, by the way. Okay.
No, but to get me right, that was just basically an illustration. You know, what I read is basically that in the area of crypto assets, securities are excluded, right?
Yeah.
But I just wanted to make this image.
Yeah, and curious to see how this ends, because I think it will be quite a challenge amending the CSDR in Europe. I don't see that happening. And if there's another approach, then that'd be interesting to see. Now about the Blockchain Act in Liechtenstein. So we've got a tokenized securities, for example, what Sofia is doing. We take a stock and tokenize it. That's considered, once it's fungible, as a security, I guess, right? Thomas, that's correct. I get that. So we take a legal wrapper, put an asset in it, issue a security, such as a tokenized stock or profit participation right. That's understandable. Now in Liechtenstein, you've got the opportunity to tokenize ownership, for example, under the civil code. That means 10 people buy a Picasso together, and then you've got 10 fractions, 10 times fractionalized ownership of that Picasso. This is then considered as legal ownership under civil law and does not fall under securities regulation, correct?
Correct, yeah.
Yeah, so if now, because that concept is not similar in other in member states of the European Union, what would now happen if, for example, you want to sell that tokenized ownership in Germany? BaFin would most likely consider that then still as a security, right? And how universal is the Blockchain Act in Liechtenstein in Europe?
Universal, I don't think that it is universal in that sense, of course, or harmonized, yeah, in a purely legal sense, because it's a local act, of course, yeah. And Liechtenstein, due to its membership status within the European Economic Area, would, of course, not have the competence to do any financial market regulation which is not coming from the European Union. But different stories, of course, the more or less same mindset which exists in Europe when it comes to ownership. Of course, colleagues, if colleagues are here, please please be patient with me. I know there is one, from a legal standpoint, there is one hell of a difference between the Austrian civil code and the Swiss one and the German one and so on and so on. But at least I think when it comes to one distinction, I think Buffin could agree as well, because what makes a security in a supervisory sense? It has to be negotiable, it has to be transferable, and it has to be standardized. Standardization is if something is functional equivalent to a transferable security. Standardized is I can net things. Property is not standardized. Property is individualized. I can't net it, because if I am the owner of a Picasso, that is only one. And if I am the owner of a fractional part of a Picasso, that fractional part, that is of course not a fractional part in that sense that I have a quarter if it's divided into four of the left hand side. But still, it is individualized. And I think that is a mindset which is not only existing in Liechtenstein, but which is shared with other regulators, or has to be shared with other regulators as well, since that is a purely legal, civil law, legal basis which has Austria, at least, Liechtenstein, and I think so Germany in common.
Okay, got it. Christian, your question answered?
Yeah, I mean, we could discuss that probably day and night, but not here. Next time. Costs. Very interesting question. I wish, Philipp, I had the answer to say exactly to issue a stock cost that amount of money, and now we're saving like 30%, 40% by doing it on a blockchain. However, I try to answer it, okay? So first of all, you have to differentiate between securities that can already be dematerialized or issued through, for example, a CSD, right, such as Clearstream, and assets that can be dematerialized, issued in a different way, alternative way, for example, using blockchain. I don't know, and really we're trying to analyze that with clients that we have, such as the Stock Exchange of Thailand, right? How much does it actually cost to dematerialize a share? And most of it is, it's mainly margin. It's the price set by CSDs, right? So we never would be able to tell the exact amount of costs that it really is. The only thing that we know is that, for example, a company has to pay, I don't know, 180,000 euros to get listed and dematerialize their stock, and then a fee per year, which is, I don't know, maybe 150,000 to just maintain the CSD registry. Tokenization and the change legislation here is good because it increases competition. That means basically we're breaking up the monopoly of CSDs, which would lead to more providers offering such services, leading to a reduction in standard fees. They, of course, develop software and will license that to their client, but the competition will increase. So I expect prices to significantly go down for issuing securities. As far as the transaction costs on Ethereum are concerned, usually deploying a smart contract and transferring a smart contract, an asset only costs a couple of cents. Last week, it would have cost 15 or 16 euros, right? It really depends, but this is the element of transaction costs. But I think the far more interesting element is that the competition will be significantly increased, leading to reduction in costs of issuing those securities. What the exact percentage is, this is something that we have to monitor closely. I really want to answer that question. We just have to wait until prices become more transparent and we see the first transactions actually being completed.
I think you answered it very nicely, Christian, but also there is no clear answer to the question. And I think I will ask Thomas in a second the same question, because apparently, you know, what exactly are you tokenizing? Is it a security? Is it traditional car? Is it art or whatever? And to who are you tokenize it? You can tokenize an art piece in 10 pieces, you know, like 10 times 10%, or you can sell it like entirely distributed to a huge mass market, and which is then of course driving costs up depending on basically the reach of investors and also the categories of investors. Is it professional investors or retail investors? So there is no clear, you can't say tokenizing something costs 10,000 US dollars. I think it's not that easy. It really depends on the question, to whom you are tokenizing, to which countries you're doing this, and how many tokens there are, and who should buy it, retail versus professionals. Thomas, that would be my very quick take on this, even though basically I'm not a law firm who could write all these documents and laws. But would you agree with this? Very rough?
Absolutely, absolutely. That is exactly the perfect answer on that question. It depends. What are you setting up? Are you setting up a special purpose vehicle in the sense of a securitization vehicle to issue a security which is tokenized to only qualified investors, for instance? Yeah, that is one hell of a difference than setting up an entity which is keeping goods like an old timer in custody, tokenizing fractionalized or ownership on that old timer, and offering it to the public. It depends really, as you pointed out, Philipp, on the concrete case.
Exactly. And Sofia, would you have a take on this, basically making a very, very, very simple tokenization of traditional cars to say, I don't know, 100 people who want to invest in the car? Is it 10,000, 20,000? Or is it too difficult to say, which is also, of course, possible, because it's a very, very difficult, then people can also basically contact you, right? Oh, Sofia is muted.
Yes,
maybe.
so I think there's no problem. I think issuing an individualized amount of tokens is not anymore a problem, especially a cost problem anymore. I think it depends on the customers, what they want, but especially from our side, we have already established a function token pad. There's no worries if a customer wants, I don't know, 10,000, 20,000 tokens. Yeah, I think the technology is so far that it doesn't have any problems to issue that.
Okay, and your solution, Sofia, is basically that you would basically help tokenize equity of a company, and previously you would expect basically that an asset is basically packaged into that company. That's yeah. And would it maybe this question is also best answered by Thomas, I would guess so. Would it be possible that, for example, a real estate object in Germany is tokenized and transferred to other Germans, but the real estate object previously has been transferred to a Liechtenstein legal entity? I hope you know what I mean. So to be able to tokenize it, I transfer the real estate object to a Liechtenstein entity, then tokenize it such that basically one person in Germany is transferring the Liechtenstein-owned tokenized asset to another German. It sounds complicated, but maybe Thomas, you can elaborate on this question also.
Of course, of course. So basically my answer is yes. Yeah, it is possible. From a Liechtenstein point of view, if it is possible for a Liechtenstein entity to get the owner of a real estate in Germany from a German point of view, I'm asking that question because, or raising that question because, for instance, in Liechtenstein, it's not so easy to get ownership in real estate. Yeah, same in Austria, at least in some regions, because yeah. Perhaps you are aware of that. I don't know if there is an existing regulation on that in Germany as well, but let's assume that is possible.
Germany is unrestricted here. In Germany, basically quite free who to basically transfer your real estate objects to.
Okay, okay. So then the Liechtenstein entity has ownership in a real estate in Germany. Now, next step is, or next question to rise, what do I tokenize? Yeah. Is it fractional ownership? Then again, that is a question which would have to be addressed according to German law, because is it possible to tokenize ownership in real estate? Yeah, especially since there is a land register, I assume, in Germany as well, which is the constitutional fact of being an owner. I assume, yeah, at least in Austria and in Liechtenstein, that would be the case, and therefore tokenizing ownership in real estate is not possible at the moment, since that register is, the land register is not on the blockchain. Perhaps in the future. But of course, everything else could be possible if one says, okay, I think let's tokenize some kind of revenue stream, because that is an industrial real estate, and I am tokenizing that profit the Liechtenstein entity makes with renting that real estate. Then, of course, if I issue that token, which represents such a participation right in respect of the entity, which still is the owner of the real estate, that is security. If it is transferable, negotiable, standardized, but I think it is. And then securities regulation applies. And of course, if I have a prospectus in place, a German investor can obtain that one and can trade to another or with another German investor on the secondary market, OTC mainly, since Christian elaborated a bit on that, the markets are already or are in the beginning of emerging, but regulated marketplaces, MTFs, OTFs, are in the moment of dealing with those questions and addressing them. But yeah, it is possible in that way.
So it's possible, but it's not possible to basically brute force tokenize a German real estate registered object directly, but you have to do it basically indirectly by putting a legal entity sitting in Liechtenstein in between. This would potentially possible. And in case the original asset is not needed to be registered in a land register, right, then it can potentially be easier, right? But still, exactly. Thomas, it's like a very, very complex topic anyway. It's not that easy to really tokenize any asset, of course not, yeah, which is okay.
Of course, and of course that structure I mentioned now is a securitization structure, securitization vehicle, where the investor has, of course, the risk of, for instance, the bankruptcy of the holding entity which is holding the real estate without having any pledge or whatever to the land. As long as that is not possible in Germany, in Austria, it would be possible because there is some law coming from the monarchy, so-called Hypothekarschuldverschreibung, where you can tokenize, where a bond can be registered in the land register as a pledge. That is highly interesting.
That sounds very, very interesting indeed, yes. Simon, are you also operating custody business in Liechtenstein or primarily in Germany, or would you not care about the country? Oh, Simon, you are muted.
So technically, we're not a custodian. We're connecting many different players who do offer custody, and we're focusing only on the middleware and making these the different players more accessible and interoperable. And therefore, I would love to have to also include custodians across jurisdictions, and of course, a jurisdiction that has such a profile and such an well-designed, scalable law is of course interesting for us. If this answers your question.
Yeah, kind of, but I think you're right. If you're not a custody, if you're just basically a company providing custody technology, then of course this could be applied anywhere. But therefore, yes, you answered the question very nicely. Okay, perfectly fine. So I will just have a look in the WhatsApp group here in case there are any questions here which need to be answered. Okay, but in all, I think to quickly summarize our talk, I think we now know it is a complex topic. It's not as easy as you would expect tokenizing things, but still, in case you want to do it, it's possible, right? We heard that many different assets should be tokenized, even though there is no demand yet. And I think we also had a very interesting discussion about the fact that potentially in the next, say, 6 months, 12 months, 8 months, there could be very strong demand incoming from companies wanting to basically invest, but potentially also driven by fears of inflation. I think let's close at this point of time. Actually, I learned a lot and I will make up my mind about what I can suggest to Jan from Disrupt to have as a next topic, because I have the feeling that so much needs to be discussed on tokenization and Liechtenstein to be able to really spread out the message, what is possible and also what is not possible. And maybe everybody here in the room prepare for the next round. I will ask the question again, what exactly is tokenization costing? Is it 50,000, 200,000 and so on? To maybe we should basically make this as the next topic. What is the cost of tokenization? Apparently many people are questioning this multiply. So thank you, have a nice Friday, and later on this day, have a nice weekend. Thanks.